Greetings and welcome to today's webinar, Reductions in Force, Be Prepared Before a Recession Hits, presented by Corals and Brady. My name is Eric Johnson and I'm a partner in the firm's Labor and Employment Group. I focus on employment law counseling and litigation in Arizona, Nevada, and New Mexico, state and federal courts. I represent clients in matters involving restrictive covenants, trade secret protection, discrimination, and of course, reductions in force. Before we begin the presentation today, we have just a few housekeeping items to go over. We will be applying for 1.0 hours of CLE credit. If you're an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact listed at the bottom of the document. There's also an HR attendance certification form in the dashboard materials for human resources professionals to use in self-reporting. We have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are on listen-only mode for the presentation. We would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If any webinar participants have a question, please type your question in the chat box located in the upper right corner of the webinar dashboard and click submit. Every effort will be made to answer questions near the end of our time together, but we do have a lot to get through, so let's go ahead and begin. Okay, so thank you all again for attending this webinar today. As I mentioned earlier, the topic is reductions in force. Be prepared before a recession hits. For our agenda today, we do have quite a bit to go through. I first want to briefly start out with some alternatives to reductions in force. Obviously, a reduction in force or a mass layoff is often the option of last resort. So you do want to at least think about some things that you could use as an alternative to a RIF. Or if that's not possible, or if the RIF is inevitable, maybe you can at least buy yourself a little more time before conducting the RIF, as you might need to provide employees with certain notice, as we'll discuss with respect to the federal WARN law or maybe some state WARN laws. But then we'll discuss in general types of reductions in force that you might implement, as well as some of the most common claims that you're going to get from a reduction of force or a mass layoff. And that's primarily going to be discrimination claims. And specifically out of those discrimination claims, age discrimination claims tend to come up the most often, and we'll discuss some reasons why that might be the case. Some checks and balances on excessive subjectivity. We'll discuss, when you're determining the criteria for who is going to be subject to the RIF and who is not going to be subject to the RIF, you're going to use objective criteria, subjective criteria, or a combination of both. And each one has some inherent legal risk to it, and we'll discuss those. Special issues, when you're discussing or when you're planning and implementing a RIF, there's certain issues that come up that create some issues, and frankly, there's always going to be things that you're not expecting. But so you have to be in a position to be able to modify and adapt the reduction in order to address anything that might come up. We'll also discuss some pre and post decision communications, termination meetings and outplacement, the conversations you have with those who are being impacted as well as those who are not being impacted, those are crucial. And those are something that's very important, and that you want to make sure you have a game plan, maybe some talking points or some FAQs to go over with employees in those situations. We'll also discuss releases and severance agreements. If you are going to be providing severance to employees in general, you're going to want to make sure that they execute a release. So we'll discuss what's involved with those releases, as well as in order to effectuate a valid age discrimination waiver, because that provides a whole new set of obligations that you need to comply with in order to effectuate a valid age waiver. And then the last part of the presentation, we're going to discuss the federal Warrant Act. And that's involved, we'll discuss when the Warrant Act is triggered. It's usually for larger reductions in force, but if the Warrant Act is triggered, what are your obligations in terms of notice requirements as well as other obligations? There's also various state laws that could come into play depending upon where you're located. Some states have their own mini WARN laws, and even if they don't have mini WARN laws, they might have certain other notice requirements just to government agencies of reductions of a certain size. So we will just briefly go over those, but those, frankly, you can probably go through at some later point in the materials at your leisure. So, in terms of, there we go. Alternatives to reductions in force. Like I said, no one wants to do a reduction in force. That's probably the last option on the list. But there are some things that you might want to consider. And this list is by no means exhaustive. There's numerous other reasons or alternatives to a reduction in force that may come into play. But these are just some of the most common. Hiring or promotion freeze, furlough employees for a set period of time, a temporary shutdown if that's feasible, reduction in employee hours. Is that going to make things more comfortable for you, or maybe you can at least put off the RIF to see how things play out a little? Although, that does have to be a temporary reduction, because you might end up, even if you don't lay off the employees, if you reduct their hours for a significant period of time, you're going to invoke Warrant. Voluntary exit incentive plans. A lot of clients love to use those because they're not doing any involuntary terminations, at least if they get enough volunteers. But there are some risks, both business and legal, associated with that as well. And then retraining and reassignment. Obviously, if you can utilize those, and instead of having to reduce or terminate someone's employment, maybe you can retrain them, provide them with a different job if that's available. Okay, so let's say you've looked at the alternatives, though, and you do need to go forward with a RIF. What types of RIFs are there? There's essentially two. The first one is a straight downsizing within positions. So, for instance, let's say you've got 100 sales reps, and you need to reduce to 65. So you're just going to do some sort of paired comparison rankings, and maybe you're going to rate those 100 employees, and the 35 with the lowest scores are going to be subject to the RIF. The other type of RIF, which is could be a little more complicated and creates some of its own issues that maybe you don't have in your typical RIF, but that's when you have downsizing plus reorganization of duties for remaining employees. Maybe you're going to get rid of an entire department. Maybe you're combining departments. Maybe you're changing the duties of a particular position. Maybe you're creating new positions. Again, those are all going to present you with some potentially unique legal issues that you want to consider, as well as obviously the business issues. Ultimately, whatever RIF we're talking about, whether it's the first I mentioned or the second, it's always a balancing act for you as the employer. On one hand, you want to make sure you can maximize your decision-making flexibility. Things are going to change, and they're potentially going to change fast, and you want to be in a position to adapt and be nimble to address these issues as they come up. But then also you want to minimize your legal risk, because the last thing that you want when you're doing a reduction in force and trying to save costs is you don't want a bunch of individual or class-wide reductions in force. That is going to be expensive in terms of litigation costs and fees, but then also disruptive. When you're trying to focus on the business and doing a reorganization, the last thing you need to do is to have maybe your employees being deposed and just dealing with a lot of time and other issues that are associated with litigation. In terms of the legal risk, we're going to talk about all sorts of liabilities that could come out of a reduction in force. But frankly, the one that's going to come up most often are going to be discrimination claims, and whether those are individual plaintiff claim discrimination claims or whether they're class-wide. And particular age discrimination is something that comes up a lot in terms of reductions in force, maybe more so, at least in my experience, for employees who are doing reductions in force as compared to some of the other protected characteristics, race, ethnicity, sex. So let's talk about discrimination claims for a moment. There's essentially two types of discrimination claims. One is a disparate treatment claim, where a plaintiff must prove that he or she would not have been terminated but for his or her protected characteristic. And in that's your typical kind of discrimination claim or single plaintiff, where maybe the plaintiff is going to point to actions taken by his or her supervisor. Let's say this is an age discrimination case, and the plaintiff points out, well, hey, my supervisor, who's 30 or 35 and I'm 65, my supervisor would always call me old man, and he'd always be talking about having to get new blood into the company, things like that. That could be evidence of potential age discrimination. So an employee might bring, a disparate treatment claim based on the reasons why they think they were discriminated due to their protected characteristic. Disparate impact discrimination claims a little different. Plaintiff must prove that a facially neutral policy has a statistically significant disparate impact on a group of people, including the plaintiff, based on protected characteristic, race, age, etc. So maybe it's not necessarily have to be intentional discrimination, but maybe the criteria you're using, which while it appears to be a facially neutral policy, which we'll discuss in a moment, the impact of applying that policy hits one particular group harder than others. Like I said, in terms of discrimination claims, the one that I tend to see quite a bit of for reductions in force is age discrimination. And part of that is obviously if you're conducting a reduction in force and you're trying to save costs, a lot of times the more senior the employees, the larger salaries and expenses that is associated with those employees, and sometimes it makes sense if you can eliminate those positions and others, maybe the supervisors of those people can absorb their duties. So the higher positions that you're reducing, just in general, you're going to have older employees because they've probably been in the industry longer, they've been promoted, they've been in the company for a long time. So there's a good chance that you might be potentially impacting quite a few individuals over 40 years old, that's the cutoff for the Age Discrimination and Employment Act. It protects any employees who are over 40 years old. Now, one interesting thing about age discrimination claims to keep in mind is that let's say you've got 3 employees, and one's 45, one's 55, and one's 65. And you need to reduce 2 of those employees and just have one of the 3 remain in that position moving forward. In terms of age discrimination, what your initial reaction might be, well, they're all over 40, so how can there be discrimination if whoever I'm going to pick is going to be over 40? Well, you can, in the Age Discrimination and Employment Act, you can pursue an age discrimination claim, even if it's among employees who are all over 40. So in my example, if you have a 65-year-old employee who's being impacted, they can say, well, absolutely, I was discriminated against by this 45-year-old. There's 20 years age difference. That person's still got a long time. They know I'm close to retirement, so I was discriminated against because of my age. So that's something to be aware of. Just because everyone's over 40 doesn't mean you're home free from an age discrimination claim. Something that I do want to point out is that decisions based on salary are not age discrimination. And I should put in general after that statement, because in general that might be a facially neutral policy. We need to get rid of these kind of higher paid managers. We can absorb those duties. In general, there's nothing inherently discriminatory about that. You're going to save the most amount of money, and it makes sense in that particular area where you can do the reduction and absorb those duties. But what happens when the vast majority of those employees are all over 40? Well, then we could get into the disparate impact, which we'll talk about. Statistical analyses must take relevant variables into account. Sometimes you're going to have what appears to be a disparate impact, but there might be a good reason for it. Let's say you've got multiple departments in your organization, and all those departments are looked at, and it's determined, this one particular department, we can outsource that. We can just get rid of that department altogether, outsource it for, frankly, relatively minimal cost, at least as compared to those other departments. Now, let's say it turns out that the department that makes most sense for you to get rid of is comprised mostly of larger employees. If you compare those employees to all the employees in the other departments who are primarily younger employees, that might look like a disparate impact. But you have to look at the whole picture, and these are arguments that you would make in any litigation. Age, it might appear that age, there's a disparate impact on those over 40, but here's the reason why that occurred and why there was no discrimination in making that decision. And, at the end here, we have number 4, statistics might favor the employer. I mean, certainly I get calls from clients that say, Eric, okay, we just did this reduction and we need to do another one, but we're going to, kind of change it up. This isn't like the past ones. There's some unique issue here, and we think this is going to be the best way to select those employees who are going to be impacted. Obviously, if we're doing things a little differently, of course, I want to learn a little more details as to why, and are we able to justify the basis for doing that. But at the end of the day, what I want to do is I want to run some disparate impact reports to see how this plays out. Okay, let's say you do choose to go that route. I just ran the disparate impact report, and you know what? I look at the numbers, and these look, perfect. So I don't see any real legal risk for you going forward with that, even though I might have if there was a disparate impact on that same criteria. But if there's minimal legal risk, then by all means, go ahead and do it if it makes sense. Okay, I mentioned earlier for the disparate impact claims a facially neutral policy. A facially neutral policy does not discriminate on the basis of race, ethnicity, age, etc. In its wording or on its face, appears to be objective and fair and is applied equally to all applicants and employees. And then I've listed a few examples, college degree requirements, strength tests, something that's not necessarily on its face, certainly going to necessarily impact one group over the other, but the way that it comes out, it absolutely might end up when you run the numbers, like for instance, college degree requirements. Is that really a valid basis for you to be making that decision? I understand that, your rationale might be, we need to, for the marketing department, we want to make sure everyone's got a bachelor's degree and a major in marketing, because we want to make sure they have that basic kind of knowledge that they can apply. Understood, but I can tell you if someone's challenging that, and if there's a disparate impact upon some particular group, a plaintiff's counsel might say, I understand you want to have a minimal amount of knowledge that these employees have in marketing, but applying, the college degree requirement exclusively, that has a disparate impact on a particular class. And there was an alternative that you could have done, frankly. You could have said college degree or X years experience in marketing. That's going to get you to the place where you want, and it's not going to have the disparate impact. Legal framework for disparate impact cases. Like I said, you don't need to show intentional discrimination necessarily like you would in a disparate treatment case. But I will tell you also, when we're talking about disparate treatment and disparate impact, a lot of times you're frankly going to get both claims from a plaintiff or a class of plaintiffs. They're going to say there was intentional discrimination, and even if there wasn't, there's still discrimination from a disparate impact theory. Plaintiff must point to specifically discriminatory practice that caused the statistical disparity. So it's not enough for a plaintiff to say, look at the numbers. This group was, impacted much more than any other group, so there therefore must have been discrimination. You can't just rely on the numbers. You need to point out to some specific policy that created that disparate impact. For instance, maybe the college requirement. You could say, if they would have done a different requirement there, you wouldn't have had this disparate impact. All right, for non-age disparate impact cases, an employer must show that the practice is consistent with business necessity or job related. And then if the employer is able to do that, the plaintiff must then show an alternative method existed to achieve the employer's legitimate interest, and the alternative method would have had a less negative impact. And like I just said a moment ago for like the education, is the plaintiff going to be able to show, hey, you could have just put a degree or an experience requirement, and that would have reached the employer's goals of making sure everyone had experience or at least knowledge of marketing, basic knowledge, and it wouldn't have had the disparate impact. Now, what about for disparate impacts based on age? These are treated a little differently than the other protected characteristics, and I think because probably you do kind of see these claims more often, because there's often, when you're at least going up from non-entry level positions, you're going to get more senior individuals who are making more money and who are older. But for these claims, an employer need only show that the challenge policy was based on a reasonable factor other than age. A plaintiff does not then get to show the availability of an alternative with less of an impact. So, this is a little easier then for employers to prove because they just need to show a reasonable factor other than age. The plaintiff can't say, oh, well, look, if you would have just changed that factor to this other one, you would have obtained your goals and you would have had a less disparate impact. You don't need to necessarily go there in an age discrimination claim. But frankly, that's not going to stop the plaintiff from making that argument. But from a legal perspective, you don't have to jump through that additional hoop if you're a plaintiff, if you're a defendant, to have to defend against an alternative basis that's being brought by the plaintiff's attorney. Subjectivity in assessing upper level positions. When we're talking about doing a reduction in force, and I think I mentioned earlier, you're going to when you're looking to determine, who's going to be impacted and who is not. You're going to use objective criteria. You're going to use subjective criteria or a mix of the two. For lower level employees, it's much easier to do objective criteria to the extent you can, as that's probably going to be safer from a legal perspective. For instance, if you have a minimum wage job position, which, there's a very high turnover, if necessary, you can post a job on an internet site in the morning and you can probably hire a few candidates that afternoon. Those are positions that are very easy to fill. You don't really necessarily need that much subjectivity in determining who to keep. In that instance, I might argue maybe you just do seniority for that particular position. But like I said, as you go higher, if you're talking senior executives, you can't just do seniority or other objective factors. You have to put subjective components into that. What about their leadership ability or customer relationships, or are they a team player? Those are all, relatively subjective. And the courts are going to look to the procedural safeguards implemented by the employer to ensure that subjective decision-making was not used as a mask for discrimination. So, continuing to discuss subjectivity in terms of whether it's disparate treatment or disparate impact, sometimes it is difficult for a plaintiff to prove that a specific portion of the selection procedure created a disparate impact. That's certainly by no means impossible, and the plaintiff is absolutely going to try to establish that. But sometimes it's not so clear-cut because, there are, typically you're going to be using numerous subjective factors, not just one in particular that might impact a particular group. But what the plaintiff's attorney is going to do is they're going to get the demographic data, they're going to run various disparate impact reports, they're going to change the rankings, they're going to try to come up with some theories to show, why, the subjectivity that was utilized by the employer created a disparate impact or was, intentionally to do a disparate treatment towards a particular group. Okay, plaintiffs argue that facially neutral criteria were intentionally applied into a discriminatory fashion. Okay, I just mentioned that. An employer's defense is greatly aided by being able to show the checks and balances were in place to protect against misuse of the subjective criteria. And we'll talk about some of those those checks and balances actually right here. Okay, so what can you do? There's going to be challenges potentially by plaintiff's counsel to the criteria, either on the criteria that's being used to evaluate employees as to whether or not they're going to be impacted, or maybe if there's not a challenge to necessarily the criteria itself, there's going to be a challenge to how individuals were graded or evaluated using that particular criteria. So one thing that you certainly want to do is to make sure you have the documentation available to support your decisions if and when it becomes necessary, in a litigation case or through arbitration. And you want to be able to point to certain things that you did that minimize the risk of any discrimination or other claims. So, when we're talking about the written criteria and guidelines, you want to have a description of each category, that you're going to use to evaluate employees, maybe a discussion of why you've chosen those categories, and then how you're going to, score or have the managers who are going to be doing the primary score or ranking of the the employees who are subject to elimination, how that's going to work. So for instance, let's say you have technical functional skills. You're going to have a discussion of what that means, some examples, and then you're going to have like kind of a breakdown. Let's say you can score someone 0 points for, has essentially no technical skills, or is extremely deficient. Then maybe you have 5, which is deficient. 5 points is, proficient. And then you have 10 points is maybe above average. And then you have maybe 15 points is, exceeds all expectations, is a superstar employee. So, and for each one of those levels, you want to give examples of, okay, so if an employee, at least, is able to get their stuff usually on time, without, excessive supervision, maybe that's proficient. And then you'd have a definition for each of those other ones. So you can at least try to limit, the person who's evaluating. They're going to have to look at those criteria and based on that criteria, make their decision. It's a lot better to be able to point to those factors than to just say, or, conduct a RIF where you asked your your managers, let's say they each had 10 direct report employees, and you said, hey, each one of you pick 4 of your worst employees and just give me the names, and we'll put those, we'll subject those to position elimination. No, you want to have the written guidelines and the criteria, because you want to minimize any claims that the particular manager, was basing this off of improper criteria, or they were applying it in a discriminatory manner. I have also listed here a business case. This isn't a mandatory thing, but certainly I recommend it to employers when they're doing reductions in force, at least of any significant reduction in force or a series of RIFs. And a business case is basically, almost like a written document or a PowerPoint that is going to explain to third parties. Because, let's say 2 years from now after the reduction, you're in the middle of a lawsuit. And a lot of the decision makers, they may have left, they may have quit, they may have been terminated. There's a lot of memories that are not as good as they were 2 years ago. And you want to have a document that you can point to that says, oh, okay, yeah, look at this. This explains exactly what we did, why we did it. And shows the paired comparisons, shows how we rank these individuals, and then it also shows any special comments that we wanted to point out. In many instances, you want to have a business case, maybe address an issue that you think, looks like we're kind of impacting, these particular employees. It might look kind of fishy based upon their performance evaluations or their last, annual one. We might need to confront an issue there. I'd much rather address it in the business case than, for instance, later on to litigation when, we say, oh, we picked this employee for elimination because their customer relationships were horrible. We got a lot of complaints from customers. Well, what happens if we look back and at their last performance evaluation that was they got exceeds expectations. They're like, customers love this person. Well, there might be a reasonable explanation for that. And you know what? Maybe that person did have great customer relationships at the time the performance evaluation took place, but since then, maybe they had a blow up with a huge client. They made derogatory comments, and you lost some clients. Well, let's go ahead and point that out in the business case, because I'd rather address that issue from the outset than rather have the plaintiff's attorney make the argument. Look, they were fantastic customer relationships, and the company says they fired this employee because of their poor customer relationships. Well, no, my client is going to say customers love them, and look, the performance evaluation backs it up. So in many ways, that business case is going to be a very good document that you can use to justify your decisions. Number 2, ensure diversity of decision makers. This might not necessarily all be always available. And when I say diversity, I'm not necessarily talking about protected classes per se, but frankly, just diversity. Other than, let's say older white male, are there other people, and maybe there's other people from different divisions. I mean, you're probably going to want HR involved, at least in guidance to others in terms of making decisions in terms of who's going to be subject to a RIF. But you just want a diversity of perspectives, because the more people that look at it, the easier it's going to be enforced than if it was one person who made the decision and there's the argument that that person's, racist or sexist, whatever. If we've got numerous levels of decision makers that have reviewed this action and have signed off on it, and many of who are probably not going to have any idea what the demographics are of a particular person that they might be making a decision on, that's all going to be able to be utilized by the employer in any lawsuit to try to justify their decisions. Caution decision makers against using impermissible factors. That seems obvious, as it should be. However, a jury or a judge might say, well, that's an easy thing for you to do. Why didn't you do it? It would have taken you 2 seconds. Even though it's expected that they shouldn't be using impermissible factors for the evaluations, there's certainly nothing wrong with reminding. In fact, I would tell you to specifically point that out and remind individuals they can't use impermissible factors. And if they do, they're going to subject themselves to termination themselves. Determine the new organizational structure first and develop job descriptions where needed. Obviously, sometimes you're not far enough along where you're able to do that, but if you can, I absolutely would recommend doing so if you have the chance to. For instance, when we're talking about job descriptions, let's say you're getting rid of a particular employment position, and in its place you're creating a new position that's going to have some new duties, and it's going to focus on some aspects that maybe weren't in the prior position that's being eliminated. But let's say you eliminate someone because they've got poor technical skills on certain applications like X, Y, and Z. They're just not good at it, and that's why their performance evaluation wasn't the best. But when we're doing the RIF, we're looking forward. We're not looking back necessarily. I mean, certainly if an employee is a good employee in the past, that's going to be a factor that's going to come through. But ultimately, we're looking who's going to be successful in the future. After this RIF occurs, who are going to be the best people to have? And let's say, so that an individual is subject to elimination because they're not good on skills X, Y, and Z. Then the reduction happens, and then finally a job description for this new position is made, and it says, you need experience for applications A, B, and C. It doesn't mention X, Y, and Z. If I'm a plaintiff's attorney, I'm going to say, look at this. They fired this person because they don't have X, Y, and Z, and then look at the job description. It's obviously was of absolutely no importance because they mentioned some other applications. So that must have been pretext for discrimination. So if you do develop the job descriptions, then that's going to help you to be able to tailor your comments in your business case about why you may be selecting certain people for elimination. Okay, establish criteria for the type of person who likely will be successful in the remaining new positions. Like I said, this isn't necessarily who's been the best employee in the past. It's who's going to be the best, or who do you think is going to be the best in the future. So, you might be someone who might not have been the best employee in the past. They might have some knowledge or skills that are going to make them much more attractive than some of their peers. Use objective factors wherever appropriate. Like I said, especially for low-level employees, it's easier to use objective factors. But to the extent you can use them for higher-level positions, it's usually, of course, going to be in conjunction with subjective factors. But if you can use those, fantastic. And what happens a lot of times is, let's say you're doing a paired comparison, and 2 employees are tied, and you only need to reduce by 1. So how are you going to pick which employee is going to be impacted when you've ranked these people the exact same? Well, at that point, it's usually good to maybe have an objective criteria tiebreaker. So if 2 people got the exact same score, then maybe you do a tiebreaker seniority, and then that's going to be a good argument to make. Look, we thought these employees both had pros and cons, and essentially we thought they were the same. So in terms of the decision, it was solely objective. Who's been there longer? When I say, just going back to 5 for a second, now I'm looking at it, establish criteria for the type of person who likely to be successful in the future. We talked about some categories. I mean, that's going to depend on the situation and the position. But when I talked about grading, let's say maybe you have definitions and you have a pay scale, a rating scale where you do 0, 5, 10, or 15. You can do nothing else. You need to pick one of those 4. That's at least, in most cases, I think that's probably the way to go, because that's going to minimize subjectivity, at least as much as you can. Because what's the alternative? You could just say, okay, here's the topic, supervisor, just, rate them anywhere from 1 to 15. What happens quite a bit is when some employers try to do that, they get the managers who think, oh, you know what, these people are really close. And they're exactly the same in all categories, but for this one particular category, I'm going to give this person a 12, and I'm going to give that other person 11. And the person who gets 11, the 1 point lower, is going to be impacted. If that person brings a lawsuit, you better believe they're going to say, how on earth could you tell the difference between an 11 and a 12? Maybe there is a basis to justify that, but that is going to be extremely difficult, and a jury might view that, well, that's ridiculous. You should have just frankly scored them the same, especially when you had this objective criteria that you could have utilized if you would have graded them the same. Okay, 7, determine what good experience looks like. It might be, if you're talking about someone in marketing, they might be a fantastic employee, they've got 20 years experience, but that might be in the past. What is going to be involved with the job moving forward? Are they implementing some new system, which the person who's got 20 years experience have never used it, but you might have someone that's been an employee for 3 years, that's all they've done is what's going to be utilized, after the reorganization. In that situation, even though someone has much more experience, it's not the right kind of experience. Pay special attention to criteria reflected in prior evaluations. That's extremely important, because I think I mentioned it earlier. Let's say, I think the example I gave was, customer relationships. I at least want to know about it. If it says in the performance evaluation that this person, is a superstar with customers, but then we terminate them because of that because of their poor relationship with customers, that's something that we need to address in the business case. Give decision makers the tools they need, but not demographic data. Obviously, there's no need or there's absolutely no reason why someone would ever need to see the decision makers, the managers at least, who are doing the evaluations, why they would need to see demographic data. Now, for in-house or outside counsel, and maybe they're working in conjunction with HR, it does make sense for them to look at the demographic data, but not for kind of that frontline decision maker. Evaluate logical candidates against each other. A lot of times I might have a client come to me and they say, okay, we've got 20 people in this position and we need to reduce by 5. Oh, and by the way, there's also 5 other people who they have a slightly different title, but they do essentially the exact same job as these other 20 people. In that situation, then I would say, okay, well, if they're all doing the same job, then let's put all of those 25 in the paired comparison, and we'll select 5 out of that 25. We're not going to make that distinction just because they have they technically have a different title, but they perform the same job. And multiple levels of review, like I was saying, with respect to diversity of decision makers. The more people that look at the action, the better. And maybe someone's going to point out something, or maybe someone has additional info about what's going to happen in the future. And hey, it looks like we're slated to eliminate 10 of these positions, but you know what? We're potentially going to get this new contract where right now I don't think it makes sense to do 10. Let's do 5 or whatever. The more eyes you have looking at it, the better. What are some special issues in terms of methods of dealing with multiple decision makers? It's human nature. Of course, you're going to have some people, let's say we're talking about managers again, evaluating their direct reports. Some managers are going to be extremely hard. If they have a superstar employee, but that's what they expect, and if this person is doing everything perfectly, they're still going to rate them, proficiently. And conversely, you might have a manager who, if the person shows up to work, regardless of what they do, they're going to get an exceed separation. Of course, when we're drafting the guidelines and the criteria, we're going to try to address that issue there. But one thing to eliminate, the multiple decision makers coming from two totally different places. But one thing that I know a lot of my clients have done in the past in a situation like that is, if you have 10 managers and 100 direct reports and you're going to eliminate 20 direct reports, why don't you put all those managers in the same room and they can discuss, where they're at, the particular employees, hey, this person does X or Y, but they don't do this. Maybe another manager is going to say, yeah, you know what, I've got that exact same situation. Well, then you can all agree as the managers to say, okay, yeah, you know what, so for those types of employees, we're all going to rate them with a 10 or whatever the thing is. So that at least you're having that discussion. So that's going to help to minimize, a different grading scale. Let's see. Okay, other considerations: business contracts or other commitments. Do you have a busy time of the year coming up? Maybe you need to, withhold. You're going to have to do a reduction for a particular position, but maybe you hold off on that particular position for at least a few months or something. You don't do it right away. Collective bargaining agreements. Obviously, if your workforce is unionized, there might be provisions in the CBA that says if you're doing a reduction force, you can only, go by seniority. You can't, use your own subjective criteria. Or maybe the CBA contains bumping rights where essentially it says, okay, if a senior employee's position is being impacted, if they're qualified for a lower level position that's, currently filled by someone with less seniority, then the senior employee may be able to bump that person out and subject that person to elimination as opposed to the senior employee. But that's going to be governed by the CBA, so you just need to keep that in mind. In terms of employment agreements, obviously, that might dictate what the circumstances are for terminating employees. And if you do terminate an employee with that agreement, is there something in there that allows them severance, or what if you can only terminate them for cause? And usually there's, in a definition of a for-cause termination, there's a reference to reductions in force, but maybe there's no reductions in force definition within, or provision within that definition of cause, and there's no without cause termination either upon a certain day's notice or anything like that. Well, then you're potentially going to be breaching that employment agreement. So you need to think about those issues. Or if it's just, okay, well, we know there is a without cause provision, but we have to pay them severance. Okay, then you follow the agreement, but you'll at least have an idea too of what is involved and how much you're going to have to pay that particular employee or group of employees. Discrimination claims, we kind of discussed those. Severance releases, to the extent you are going to offer severance, if you didn't already have a severance plan, but you're now going to offer severance as part of the reduction, obviously you're going to want to include a release in exchange for that severance. If you want a valid age discrimination waiver, you're going to have to jump through a lot more hoops for a group termination, and we'll discuss those in a moment. Payment of wages. Do you have a policy that you pay out accrued but unused PTO, or unused PTO or vacation? If so, well, then you're going to have to pay that. But you at least want to be aware of it to see, do you have the funds ready for that, and are you okay with doing that, and what's the timing? Does that make a difference? There's also, ERISA, COBRA, immigration. Do you have employees on visas? How's that going to impact, what happens to them? These are all things, that you need to think about when you're in the process of preparing for your RIF. Conducting a legal privilege review. One thing that I'll do for clients is I'll do a statistical analysis. I'll run various disparate impact reports that, they'll give me the data. They say, here's the demographics, here's who we're slating for termination. I'll run some reports and say, hey, okay, it looks good. Or, you know what, it looks like this one particular group is being impacted more than others. So let's delve into that a little deeper and see what's going on there and see if there's anything we need to do. So, of course, there's always going to be special cases, protected discrimination, harassment, or retaliation complaints. let's say someone files a discrimination charge with the EEOC on Monday, and then you're going to tell them on Wednesday that they're going to be subject to a reduction in force. I mean, naturally, that person is most likely going to say, "Oh, I just filed a charge of discrimination. Now I'm being fired." That's obvious retaliation. Now, maybe that's the case. In terms of they filed a charge of discrimination, you think it's bogus, and you've got good defenses, and yeah, the timing, it looks bad, but it is what it is. That person is by far the worst employee, and you're going to go forward with it. You are going to get immediately an amended EEOC charge that's going to say retaliation, but you at least want to be wary of what's going on with particular employees. Likewise, have they done any whistleblower complaints or recent or current ADA accommodations? Those are just things, and like I said, they're not necessarily going to change anything, but you at least want to know about it because you want to see what's potentially going to come forward. Dealing with concerns raised in the legal review, and I'll say when I'm doing that disparate impact analysis and then I'm discussing it with the client, usually the HR folks, that's obviously a privileged review, and you want that to be privileged. You don't want to disclose the fact that, we looked at, the demographics, and we saw there was a disparate impact, but no, we thought we were fine. Let's have that in a privileged communication. Hiring freeze, of course, you don't want to be hiring for a position that you just impacted. I mean, obviously that wouldn't normally happen, but you just want to make sure all the lines of communication are open, because maybe you always are hiring for that low-level position, and maybe the word never got to the hiring person, like, hey, you need to knock off the hiring. Statutory notice requirements, we're going to discuss briefly the Warrant Act, and maybe there's some state mini Warrant Acts. But before we go do that, just pre and post decision communications, termination meetings, outplacement. When you're preparing for the meetings for the reductions with the impacted employees, obviously you want to have a game plan. You want to make sure everyone's on the same page and these meetings are being conducted in the same manner. You probably want to prepare a list of talking points, maybe an FAQ that either you just go over with the employee during the meeting, or maybe you hand it to them along with some sort of other informational sheet. And you just want to make sure that everything is consistent. And what's it going to look like in the termination meeting? You're going to probably want at least two people in there. So you have, instead of just a he said, she said, you at least have two people who can testify, what occurred, as opposed to just, one-on-one. Outplacement, a lot of employers do that. Frankly, one of the, best things you can do to avoid a lawsuit, when you fire someone, is to help them get a new one. Because if they have a new one, then they're more likely to move on. But if they're struggling, they're terminated, and they have no other job and they can't get a new one, then they very well might say, well, you know what, I think I am going to file a discrimination claim because I think it was improper and I don't have another job. And you want to meet with the other people who, let's say, their position was subject to elimination, but they weren't picked. They're still going to be concerned and say, well, was this just like the first wave? Am I going to, are you going to meet with me in a month and impact my job? Obviously, there's a lot of those questions that you might not be able to answer. I mean, you certainly can't give absolutes, but to the extent the thought process is, right now, we think this is going to be sufficient. Moving forward, we think this is just the right amount of this position. We can't predict in the future for sure, 100%. But our plan is right now we're not going to make any more reductions. Likewise, people in unaffected positions, they might be thinking the same thing. Okay, well, you haven't gone to my department yet. Is that coming? You want to have those discussions too, because otherwise you might have those people voluntarily leaving. In a manner that's bigger and that, there was never any concern that you were going to impact anyone in their positions. Okay, voluntary severance plans. A lot of employers like this because, they don't have to do the involuntary termination. They're giving, the employee, hey, this is a good package. If you want to do it, go for it. And then if there's enough people who volunteer for it, then you might not have to do any involuntary RIFs. Problem you get is, if it's a good severance package or an exit package, a lot of times, you might have your top performers say, oh yeah, okay, this is a good idea. And, I'm a superstar. I'm going to get a job. I'll get a new one by tomorrow, paying just as much. and I'm going to get the severance. Who's not going to probably volunteer, at least usually, are some of the lower level employees who they're still bewildered how they got this job and how they're getting paid this salary. They know if they're fired or they quit, they're not going to get another job that pays what they're doing now. So you might end up with a situation where you kind of lose your best, your talented employees, and you're left with kind of the ones that, frankly, you would have been happy if they would have chose to depart. Releases and severance agreements. For the Older Workers Benefit Protection Act, for those individuals over 40, for a group termination, you need to jump through a number of other hoops. For a single termination for someone over 40, you have to give that person 21 days to consider the agreement and 7-day revocation period. For a group termination, which is going to be what a reduction in force is, and a group is, extremely, broad in terms of a group means more than one. So if you have 2 or more reductions, that's considered a group termination. And if that's the case, you have to give that employee 45 days to consider the agreement if they want, still the 7-day revocation period. But then you also need to provide those affected employees who are over 40 with information, concerning the job titles and ages of the other people in that classification, that job classification, those who were subjected to termination or the RIF and those who weren't. And then that individual can look at that info and they can maybe say, okay, yeah, you know what, it looks like there is a big disparate impact. I think there might be something here. And maybe in some situations you're not worried about age discrimination claims. Maybe you have an extremely young workforce and that's just not going to be an issue. So maybe you don't have, if you're not concerned about that, then you don't necessarily have to go through those hoops. Okay, just for the remainder, I've got quite a few slides on these, but my purpose was just to give you kind of more information than frankly we're going to talk about today, because the issue of warrant, that's its own topic onto itself, but I just wanted to go over a few things right now before we part. Just so, as if you don't have enough to think about when you're thinking about all these other things, you also have to worry about the federal warrant as well as the state warrant. Anyway, the Federal Warrant Act was enacted in 1988 and requires covered employers to provide employees with 60 days notice before plant closing or mass layoff. In terms of the notice that's required, you need to provide the employees with certain notice about the reduction in force. You also need to provide the union with notice, and are there going to be bumping rights, how that's going to work. In terms of whether or not WARN, you're going to be covered by WARN or WARN is going to be triggered, you're going to need at least 100 or more full-time employees at a single site of employment, or you need 100 or more employees full-time or part-time. But for those part-time employees, in the aggregate, if they work at least 4,000 hours per week, excluding overtime, you might then meet the WARN threshold, even though you don't have 100 full-time employees. Employees are considered part-time if they've worked either an average of less than 20 hours or less than 6 the last 12 months. Notice requirements, in addition to the employee and the union, you also need to identify or provide notice. Before we go there, employment loss means termination other than for cause, voluntary quit, retirement, layoff exceeding 6 months, or reduction in hours worked for 50% in a 6-month period. Obviously you want to be careful. If you're about to do a reduction in force, and then 3 days before you announce it, you fire someone because they did something that warrants discipline or termination, that might be valid and you might move forward with that. But you know what? Their argument is probably going to be hey, they fired me just pretext before they did this RIF because they knew my scores would be fantastic. So they're just trying to get rid of me now before they even had to put me in a paired comparison. So you want to be aware of those things. In terms of plant closings or mass layoff or reduction in hours, for a plant closing, you need to impact at least 50 employees. This excludes new and part-time employees. It's going to cover anyone who's impacted within a 30-day period, but also you want to look 90 days back and 90 days forward, because if those are all part of the same RIF, but they just maybe have little different stages, then that's going to impact who you need to provide notice on, and it's also going to impact the titles and the ages of all the people that you need to provide certain employees for the age discrimination waiver. A single site of employment, when I'm talking about 50 or more employees who are being impacted by a plant closing or a mass layoff, we're only looking at a single site of employment. I mean, obviously, if it's just one building, then yeah, that's your single site of employment. But what happens if you have continuous buildings? Maybe you have one main building and right next to it a couple smaller ones, or there's at least maybe just down the road, it's not too far. In certain circumstances, those might you might have to group those together and consider those a single site of employment. What I do is I'll probably run 2 disparate impact analysis. I'll do it one for what we think is a single site, but then also I'll maybe include these other ones to say, hey, there's a chance that these might all be grouped together, so let's know what the risks and obligations are if they are considered to be one single site. Actions triggering notice obligations, mass layoffs. Okay, like I said, you need at least, whether it's a plant closing or a mass layoff, you need at least 50 employees. But a mass layoff is a little different. You're not completely shutting down the facility or the building, but you are going to impact over 50 employees. But those 50 employees, or whatever number you're doing, it also has to mean at least 33% of the employees at that single site of employment. So, I mean, you could have a situation where, let's say you have a building and you've got 500 employees, and you're going to, get rid of, or you're going to subject to termination, 75 employees. That's obviously over the 50 threshold, but it doesn't meet the 33% standard. So that's not going to trigger warrant under those circumstances. Aggregation, I mean, these are, I don't want to get into the weeds with a lot of this stuff, but one thing I will point out, a lot of employers have traveling employees or people who work remotely. So how does that work? What if you're going to be impacting those individuals, or you are not going to impact those? How does that come into play? Where do you count them? If they're working out of home or if they're working out of a suitcase, generally it's going to be where that person reports to, or where they get their work assignments, or maybe they periodically come into one particular facility. You need to figure out what that facility is, because you're going to use that, and you're going to count them towards the warrant numbers, towards that particular single site of employment. Okay, when must notice be given? Like I said, it's 60 days prior to an employment loss, generally. Who must receive notice? Like I said, the employees, the union. Also, you need to do the highest local government official, municipal or county, and the state dislocated workers unit, just so they know what's going on, because they might then activate resources, job retaining or market job, information, to the impacted employees. They might be able to do, different things to help those impacted employees get new employment. Which employees are not entitled to notice? Are employed. Obviously, if someone's an independent contractor, they're not going to be considered an employee, but then, as probably it's a hot issue right now, is someone an independent contractor or an employee? So you definitely want to consider that. If you've got a heavy number of independent contractors, what happens if these employees claim they're employees? How is that going to impact our notice requirements or what we need to do? Okay, contents of notice. These are just things that you need to include when you are providing employees or the government agency or the union information about the RIF. It's not in all circumstances absolutely mandatory that you provide 60 days notice. There are some situations that arise that you could not have planned for. For instance, a natural weather disaster that came out of nowhere and it devastated your business, and you're going to have to now do layoffs as a result of that. That was unforeseen. You couldn't have given 60 days notice. Or if there was a strike or lockout, and that made it where you had to, proceed with a reduction in force on completion of a particular project. I mean, if you said we're hiring you until this project is done and it'll be done within 1 year, then they always know what the termination date was going to be, so you won't have to do it there. All right, well, we're just about to wrap up. Like I said, a lot of these you can just review at your leisure, and things to consider, when you are thinking about whether or not you're going to have to do a RIF. Let me just go at the changes in ownership. So let's say you're merging or you're selling your business. There are some exceptions, but you need to look at that closely. If you're being purchased, is that person going to take on all your employees? Are there things that, even if a warrant isn't necessarily triggered, is that going to trigger employment agreements or severance payments or vacation, PTO? Is the new buyer going to assume those obligations? You're going to have to address those things probably in the purchase agreement. Potential warrant liability. You're going to be if you don't provide them with 60 days notice, then you have to provide them 60 days of wages. Now there's a split in circuits as to when are we talking about 60 wages or 60 days? Are we talking about 60 calendar days or wage days, like the days they would have worked within that 60-day period? Most courts say it's working days, but there are some that say it's calendar. Penalties up to $500 per day. If there's ongoing litigation and those are compiling day by day, and the wheels of justice move slowly, so that could potentially turn into a significant amount of money, as well as, of course, attorney's fees. Enforcement for Warrant Act claims, you need to bring those in federal court, but there's various other claims that we've been discussing that can be brought in state court. So finally, just the last thing here, I've listed a number of states. This is, again, a not exhaustive list, but some of these states that I've listed here have their own mini warrant requirements, and that might be a smaller threshold. Maybe you don't need 100 employees, maybe you only need 50, and maybe you don't need to impact 50, maybe you only need to impact 25. So you want to make sure that you're aware of those. And then also, like I said, there's some states that don't necessarily have a mini warrant, but they do have some kind of unique notice requirements where you need to, for a termination of more than 25 employees on one day, you need to notify the state unemployment agency, stuff like that. So you just want to be thinking of those things. I don't see any questions, but I do notice that our time is up. I'm more than happy to answer any questions offline. Feel free to give me a call or shoot me an email, and I will promptly get back to you. I'm more than happy to talk about anything. Other than that, I think that is it. Thank you very much for your time.